Welcome everyone to this policy outreach seminar. I am Jane Drake-Brockman from the Institute for International Trade at the University of Adelaide in Australia, where we host an academic network focused on trade and investment in services, supported under the Erasmus Plus program of the European Union. Now, we are joined this evening by all of our academic network partners, but also by a large number. We have a global audience for this event, a lot of government and non-government and business community representatives. We also have some attendees from the International Press Corps. So I want to make just a few quick housekeeping and some press protocol points. So first of all, for the discussion section, I'd like to ask everyone to use the Q&A function and write their questions in. If you are from a media outlet, I ask please that you add into your name and to the question so that we can see it, your media outlet affiliation, please. And if your questions, if we have time and they are put to the panel, I ask please that any attribution in terms of our guest speaker, please be from a representative of the European Commission rather than a personal attribution. So for the press, any responses to questions that come from the press, no personal individual attribution. Meanwhile, this is otherwise an event that is completely on the record. It is being recorded and it will be available on the university website. For everybody else putting a question, I please ask that the speakers not respond in writing to those questions, but as moderator, I will try and gather them and collect them. We have a very short time frame. We've only got 75 minutes for this event. So straight on now to our very exciting and very contemporary topic, the EU-China Comprehensive Agreement on Investment, which has a brand new nickname, the CAI. So we have a new acronym and a new nickname and a new, from an academic point of view, a new fascinating agreement to have a good look at. And of course, it's brand new. It was signed in principle on the second last day of the year 2020, less than a month ago. And the text only became available the day before yesterday. So we've all been trying to read it and digest it. And we are incredibly lucky to have with us somebody who can explain the content to us. That is our keynote speaker, the EU chief negotiator of the agreement, Ms. Maria Martin Prat. And her next big job, of course, after this event is to see this agreement through its ratification process in Europe. So another big job ahead. Just a quick introduction of our keynote speaker. She is director in the European Commission Directorate General for Trade, where she is responsible for services, investment and intellectual property, as well as Northeast Asia. She was previously head of the copyright unit in the Communications Networks Content and Technology DG. And she's worked also on internal market matters, particularly heading up the unit that looked after free movement of services and freedom of establishment. So she has a great deal of services trade experience as well as investment policy. She also worked in the cabinet of Commissioner Almunia, which at the time was responsible for economic and monetary affairs. And she has also worked in the private sector with the International Federation of the Phonographic Industry and also in the European Parliament. She is admitted as a solicitor in Spain, has 2 postgraduate degrees in European law from the European Institute of the University of Amsterdam, and from the Institute of European Studies at the Free University of Brussels. We have two panelists who I will introduce afterwards, and I hand the floor immediately now to Maria Martin-Pratt to tell us all about the EU-China Comprehensive Agreement on Investment.
Thank you. Thank you very much. And let me thank as well for the opportunity to be with you and to be able to present the agreement, which, as you said, was concluded in principle at the end of last year. Not in a sudden, as it's been portrayed, but by some, as these were negotiations that had been ongoing for 7 years, but in particular had taken quite a dynamic in the last 2 years. But as you say, the political conclusion is now done, and we start the process which in the European Union can take a certain amount of time to have now the agreement ratified, which means endorsed by the European Parliament and concluded by the member states in the Council. Now, I will very briefly explain to you what KAI is, second, the systemic value of KAI, and third, how does KAI fit within our overall strategy vis-a-vis China. In terms of KAI, KAI is basically a tool that aims at rebalancing the investment situation vis-a-vis China. We have operators that face significant market access and behind the border barriers in China, whereas, as I'm sure you know, the EU market is open, and the internal market rules in Europe do provide a level playing field for all. So basically, what we are trying first and foremost is to rebalance that current situation. It is important to keep into mind that we, the European Union, have bound a big part of our market openness in services, and we've done that in the WTO, whereas in comparison, you can see that the commitments that China has vis-a-vis other members of the WTO in relation to market access for services are far more modest. Now, that is the first achievement, if you want, in terms of KAI, is the fact that China has now commitment, the openness that it has been granting in market access for services in the last 20 years, and that it had not bound when it joined the WTO. At the same time, China has taken commitments in areas it had not taken before, which is notably as regards manufacturing, and it has also provided commitments in areas of services that it had not committed before. Now, the second important element that you will see in KAI related to what we have referred to as the level playing field. These are disciplines that aim at facilitating the functioning of our businesses once they are in the Chinese market. We include disciplines related to domestic regulation, such as, for instance, authorizations and accreditations. We include disciplines related to transparency. And important, you will see a set of disciplines related to rules against the forced transfer of technology, disciplines for the behavior of state-owned enterprises, and transparency rules as regards both SOEs and also subsidies. In subsidies, we have specific general transparency obligations for subsidies in the area of services, which somehow complement the existing obligations under the ASEM agreement in the WTO, but we also add transparency as regards subsidies in services, which were not covered by the WTO obligations. And then In the last part of the agreement, if you want, of these three baskets, market access, third, and equally important from our point of view, are the obligations related to sustainable development. For the European Union, sustainable development goes as an indispensable part of our trade and our investments agreement. And here we have agreed provisions related to environment and climate, including the implementation of the Paris Agreement, as well as corporate social responsibility and labor. And I'm sure we might discuss going forward the commitments to ratify the ILO Core Convention on forced labor. Now, CAI also, and this is important to highlight, has a system of dispute resolution, state-to-state dispute resolution, which is similar to the ones we have in our FTAs and follows the model of dispute resolution that is familiar to all of you, and that we do not hesitate increasingly to use when we think is needed. Now, going back as to how we see the value of CAI from a systemic point of view, there is a first element that is very important to keep in mind. CAI is not a full FTI. This was from the beginning by design. We did not want to embark in a full-fledged free trade agreement negotiation. We wanted to have a targeted instrument specifically to facilitate, to liberalize the area of investment in services and non-services. But the result of this, as many of you will know, is that as far as services commitments is concerned, CAI is not shielded from the MFN obligation, the Article 5 of the GATS agreement, which basically means that lifting of commitments that has been agreed by China from the commitments they had when they joined the WTO in 2001 to the level of openness in the area of services that they have today, that general lifting plus the extra commitments that have been taken are not only to be recognized to European Union investors, but they need to be recognized on an MFN basis to all of the members of the WTO. So from a systemic point of view, as far as services are concerned, what is in CAI for market access is important not only for European investors, and I think this is an important point to make. Also systemically, I think CAI is lifting the bar on a number of other issues. If you look at, for instance, rules against forced technology transfer, we don't have most of them in WTO. You could argue that a number of those in relation to, in particular, TRIPS play such a role. But basically, it's been the US in the Phase 1 agreement and the EU in CAI have really now put on the table a complete catalog of rules that can help in the fight against the forced transfer of technology. Again, these are now elements that can be used, if you want, in terms of future rulemaking, future discussions, including in the WTO. And the same goes, I think, as far as some of the issues related to what we will call a competitive neutrality, so in relation to SOEs and subsidies. Now, I am a bit mindful of time. I would like to explain to you as well, how does CAI fit within our overall strategy with China, because I think that it is also very important. This is an issue that we have been working on for quite some time. We recognize the importance China has for the European Union, not only from an economic point of view. We believe that to address a number of the challenges we face today, whether it is climate change or others, we need to cooperate with China. But we also believe that there are differences in the values and the political systems we have, and also that we need to make sure there is no damage to neither our security, not the functioning of our internal market as a result of some of the practices that we see and the effects we see resulting from the Chinese state-led economy. So in the same manner that we have been working in the negotiations of CAI, we have also been working on a number of what I will refer to as autonomous measures. And these autonomous measures, I will say, can be classified in the following manner. We have a number of autonomous measures that are in place to protect European security. We have screening of foreign direct investment. We have now a regulation as regards the control of export of dual use and other technology. And we have, for instance, as well, a whole toolbox as far as the deployment of 5G technology is concerned. These are important, they are in place, and they are not affected by CAI. We've been carefully when drafting the commitments to make sure that that gets totally and stays totally unaffected. We are also looking into tools that will help protecting our internal market, in particular as regards the effects of subsidies. We do have a very strong control of subsidies, of state aid, as we call it, within the internal market. That is not necessarily the case in other countries, and China is a particularly poignant case. And we want to make sure that there is not distortion in our internal market created by those subsidies granted by a third country. When, for instance, investors are trying to acquire companies in Europe, or for instance, bidding for public procurement. So that is an instrument that our Directorate General for Competition is working on and should be on the table before the summer. Equally important, so as a second category, if you want, of autonomous measures that help us protecting the integrity and functioning of our internal market. And then very important as well, is the area related to our values. And there I will put sustainability, but also human rights. And even though we think it's very important to engage, for instance, in the ratification of the ILO conventions and to work with other countries to make sure that practices such as forced labor are eradicated, we don't believe you can achieve that goal on the basis only of what other partners may be willing to do, commit themselves to do under a treaty. And we are looking into as well autonomous measures, both to fight against forced labor, and there is work ongoing in the area of due diligence, and legislation should be as well should be also proposed by the summer. In that area, and also in an area that goes well beyond trade and is of a much more global nature, which is human rights. There was the adoption before Christmas of a new EU global human rights sanctions regime that will allow to target human rights violations by listing individuals as entities, and could lead to freezing of and specific consequences, as I say, for entities and individuals. So that is a brand new instrument. Again, completely mindful of the fact this is not trade policy, but what I want to make the point here is that the European policy vis-a-vis China is a sophisticated policy that includes a very necessary engagement with China, but also very necessary autonomous measures in terms of security, economy, and values. I think I will leave it there, and I am happy to get into comments on the specific aspects of the treaty. I don't want to get into too many details because then it will have been far too long. But happy to get into details.
Thank you very much. Thank you. It's a very comprehensive overview, and I'm going to, well, clearly we're about to see also some forthcoming autonomous measures, unilateral steps taken by the EU, which will probably be of great interest to your civil society stakeholders in this area. So that's very interesting to hear that there's more to come, in a sense. I'm going to move straight to introduce a key European stakeholder for this agreement, Dr. Pascal Canais, Managing Director of the European Services Forum, which is the voice of the European services industry in international trade and investment negotiation, a position Pascal has held for 20 years. And I know that a number of his corporate measures are also participating and online at this event. Pascal has a doctorate in European law from the University of Rennes in France. He's worked as a legal expert with the European Commission in the late 1980s and for nearly a decade as international affairs advisor with the European Banking Federation. He's a long-standing member of DG Trade's Civil Society Contact Group. He's a member of all the European domestic advisory groups for all of the FTAs, and he chairs the advisory group on the EU-Singapore FTA. So he's a key stakeholder serving on DG Trade's expert group on trade agreements. I've bumped into him regularly at all WTO ministerial conferences where he has been participating as a key commission advisor. And on services, particularly, Pascal's business network is very extensive. He's a core member of the Global Services Coalition, through which he collaborates with services business stakeholders right across the globe. So over to you, Pascal. What do you think of the CAI?
Thank you very much, Jane, and thank you all for this invitation. Very glad to participate to this event. I'm going to give you my perspective as a representative of the services and why do we believe that it is a good agreement for the services, because as I'm going to try to explain, we have don't have good trade relations with China in terms of volume so far compared to the rest of the world. Here you can see that the export of the EU to China in trade and services is only 19% of all trade with China, while the world average is 32%. And China is not also really trading with us in terms of services compared to its world average, where only 7.4% of all trade from China to the EU is into services, which is really small. If you look at the last trend on trade in services, yes, the export have increased in the last 6 years, 100% for the EU, 54% for China in the last 6 years, but the volume is not big, and the EU export to China only 4.8% of the total EU services. So all services around the world, only 4.8% is going to China, which is a small proportion compared to the size of the country. If you look where, in terms of which sectors do we trade with China, compared to the world, which is the box average, we are trading more into transport and travel, and you know that the pandemic in 2020 would have seriously reduced this, compared to the other countries where it is only 17% for transport and 15% for travel. Normally, these two sectors are now taking less importance, and we have more export into other business services or financial services. You can see here only 9%, only 2% of the EU export to China is financial services, while the average is 9%. This is to tell you that we would like to trade more with China. If we look at the foreign direct investment now, the EU is, you can see here, by far the biggest exporter, if you wish, or sending of foreign direct investment around the world, and the US is coming second. China is already important, but we still have a long margin to go. We would like to export more investment to China, and we would like to have China investing more into the EU, and we hope this agreement is going to be helping this. But you see the trend of last years, the last 6 years, even if the outward investment to China has increased a bit, even if in China, because it started lower, it has increased by nearly 200% in 6 years. even the last years, we have started to see that it is declining or not increasing very much. So we believe that there are a big margin of maneuver to get more investment into the EU. Talking about services, well, first of all, showing these figures, I know it's old figures, but as you know, we're very poor in getting statistics from the services sectors and for the FDI. So here is the old measures, but the trend has not changed very much since. The EU outward foreign direct investment to China by the European Union represent only 2.4% of all our investment in the world, which is really not proportionate compared to the size of the country and the size of the economy. And for the investment coming from China to the EU, inward investment, only 0.6% of the total is coming from China. So it's really minuscule, and there are a lot of place to increase this. Normally in the world, outward investment by the EU, around 60% is going to services sectors, and 87% is actually going into the European Union in services sectors for all the FDI. So I think that is really interesting, because you can see that when companies are investing into the European Union, large part of this investment is coming to the services. Let's have a look at what is the share of China into this. And I think this is really interesting, looking at this perspective of the KAI. You can see that for the European Union, contrary to the 60%, we only have 40% of the investment going to China into the services sectors. And that has not evolved in the last 6 years. The share has remained the same. While on the other side, and that is showing, I think, that clearly for the services sectors, we don't have good access to China, and therefore we're not able to reach the normal level that we do normally into investment in other countries. And while on the other side, China has significantly increased its investment into the EU and gone from 28% from the services in 2013 to 80%, which is a normal average. So China has been able to adapt itself and invest into the EU into services. So we would like to get the possibility to do the same for the European services sector. So let's come to the KAI, but maybe even before coming to the agreement itself, I think it is important also to remind ourselves what has happened in China internally. In 2019, they have adopted the foreign investment law. And that is a significant law, because that is showing that internally China has shown some signals that they want to improve the possibility for foreign investors to come into China. They have eliminated some joint ventures requirement for some sectors. They have prohibited some transfer of technology. They are now using the negative list from already a long time ago, but now it's becoming a bit more significant. And therefore, we have started to look closer to China even before the signature of the agreement. And also, more importantly, probably, the law expands investment opportunities to the whole territory of mainland China, and not only, as it was most of the case earlier, to the pilot free trade zones. So that is a very good move from China, but of course the law was still is complicated to understand. We are still looking for more clarification, and more importantly, the unilateral reform is non-binding. So what we are very happy with this new agreement, that the EU negotiators have succeeded in incorporating many elements of this reform into the EU-China Comprehensive Agreement on Investment. And in addition of the market access I'm coming to, as Maria told us, these binding is actually also accompanied with many obligations on the level playing field, on transparency, etc., which is making things even better. So in terms of market access, a major aspect of the agreement are, first of all, I think, and we don't repeat this sufficiently, binding and ratcheting all autonomous reform that China has undertaken since 2001, so the accession to the WTO. So I think the agreement by itself, by binding all of these natural reforms that I just mentioned, is a GATS++. In addition to that, the agreement is also including commitments taken by China with many other trading partners before the EU signed an agreement. So the US-China Phase 1 deal, the China-Australia FTA and the RCEP as well, although, as we know, RCEP admittedly is rather poor on the services part. But then also, as Maria said, the agreement is also binding some new market access opening, and very interesting, as Maria said, it is on an MFN basis. So it's a kind of a DDA second without having to go back to the WTO machinery, so that we are actually making a gift to the rest of the world. And we look at the different services sectors where China has taken commitment. I'm not going to go through all of this, but you can see that in many services sectors, China has taken significant commitment. So removing the joint ventures requirement in many instances, like in financial services, in the health services, allowing private hospitals in some cities in China. The ITC services sector, I think, is also very important, where the investment ban for cloud services has been lifted, etc. International maritime transport and air transport related services, I think, is very important, in particular for the world transport of goods. So that is, of course, beneficial not only to the services sector, but also to the world trade in general. Business services sectors, with elimination of joint ventures requirement in real estate, in advertising, in repair and maintenance, in management consulting. So all of those are services sectors where our companies are very interested in. Environmental services, with the removal of the joint venture requirement, and that is of course linked to the climate change and environmental aspect of the agreement. So that is going in the right direction. Construction services is a sector which was rather closed, and we know that the construction services in China are very competitive, but it was not possible to compete on a level playing field before. Now they have eliminated the projects limitation, which were reserved into the GATS commitment, so that is welcome. And also very important to say, China has accepted to take some commitment of mobility of people linked to the establishment. So it's not an FTA, it's an investment agreement, and therefore we talk only about more three related issues. So the establishment, and then you can have people coming to this establishment, but the fact that we can bring people in our subsidiaries and joint ventures, I think is very important. So to conclude, Jane, maybe also saying a word on the kind beyond the market access issue, which is of course very important for the services sectors, but I think it is very important to say that China is making commitment to ensure a fair treatment for EU companies so that we can compete on level playing field. And that is, as mentioned by Maria, in terms of disciplines for state-owned enterprises. And I think, of course, if you have a competitor for which you do not compete because they have an advantage, that is not fair. And I think that the transparency on the obligation by the state-owned enterprises to say who they are, the shareholders are, and what kind of operation they are doing is very important. Transparency of subsidies, it has been mentioned. I think it is a premier that we have now disciplines on subsidies in the services sectors, because that didn't exist at all. I mean, for goods, we have the agreement WTO, but nothing on services existed. So that's a welcome. And finally, again, binding the rules of against the forced transfer of technologies, which of course is very important for companies. Also, the S&D, the trade and sustainable development part is also very important. The commitment of forced labor and ratification of the ILO Fundamental Convention, I think, are going to be very heated debate here in Europe. And the climate change, I think we heard President Xi Jinping talking about this issue at the Davos this week. In his speech. So I think China is committed for climate change, but maybe we have more difficulties in terms of labor and ILO convention. So I think that is into the agreement is really good. There is no doubt that the issue of the enforcement of these commitments, notably for the human rights, as has been mentioned by Maria, is going to be debated in Brussels, and that's good. And the member states and the European Parliament are going to play their role and ask for clarification before ratifying the agreement, which is absolutely normal, and we have to demonstrate that this is going to be possible. So to conclude, the European services firms, I think, support the ratification of the CAI, because we believe it is a tool to engage with the Chinese authorities on these issues. So of course to market access, but also to have a tool to engage with these issues. And also has been mentioned by Maria, we support the setting up of the relevant internal tools to ensure the respect of the fundamental rights. So corporate social responsibilities by our companies, responsible business conduct, enforcing rules for the due diligence are tools that we in our companies will respect, and therefore I don't think it is not by signing an agreement with China that we're going to solve the human rights issue. It is only if we can engage that we will be able to influence the debate. Otherwise, we can only watch and cry. So I will stop here, Jane. Thank you very much.
Thank you very much, Pascal. Again, a very comprehensive response, I think, to the Commission's presentation. Our second panelist is Brian Mercurio. He is the Simon F.S. Lee Professor of Law at the Chinese University of Hong Kong, where he has been located since 2007. He specializes in international economic law. His work focuses on the intersection of trade law and IP, intellectual property rights, free trade agreements, trade and services, and international investment law. He's co-author of one of the most widely used case books on WTO law and co-editor of the leading collection put out by Cambridge University Press on bilateral and regional trade agreements. He has also taught law at the University of New South Wales in Australia, worked as a trade negotiator and policy officer, and practiced international trade law, both in the United States and in Australia, and he maintains an active consultancy practice. Now, as I see it, reading a 1,000-page 21st century FTA is one thing, but knowing how to read a modern standalone bilateral investment agreement, and in particular one that involves market access commitments, is quite another thing. And Brian happens to be my recommended go-to person on international investment treaty matters. So I'm hoping, Brian, that you can explain some of the details of CAI. I want to just tell you there are a number of questions already coming in, which I feel sure that you will cover off automatically. But there are questions, for example, on whether or not this is a mixed competence agreement, questions on does it have ISDS or not? So I'm sure you'll cover those as a matter of course, but just letting you know. Thank you, over to you.
Okay, thank you, Jane, and thank you to the two previous speakers and attendees for making time to join us today. I'm not going to cover the entire agreement. I only have 10 or 15 minutes, but I'll just make 6 points. And essentially, I'm taking a pragmatic approach. I'm not overly critical of the agreement, nor do I really think it's going to be a game changer. The first point I want to make is the CAI is a unique agreement, and in that it creates unique challenges, right? The CAI is certainly not a trade agreement, despite including services to some extent, right? It doesn't have provisions on goods and tariffs and government procurement, IP, technical standards, etc. This is why it is not a mixed agreement and does not require ratification at the national parliament level, but I'll let the Europeans speak on that later. In terms of investment, it's not a traditional investment agreement either. It does lack the substantive rules of protection, such as expropriation, fair and equitable treatment. It also lacks kind of modern features like anything on investment facilitation, as well as, of course, not including state-to-state dispute settlement, or sorry, investor-state dispute settlement, or even the EU's favored new multilateral investment court. Now, I think these are somewhat curious omissions, given the negotiating an investment protection agreement was one of the original EU negotiating objectives, and that this agreement was meant at that time to replace all of the state level, member state level bids with China. Of course, those now will remain in place, and investor state provisions in those agreements obviously remain in force. Now, I think it's also fair to say that this agreement was not what was envisioned in Brussels or Beijing when the negotiations not only commenced 7 years ago, 35 negotiating rounds ago, but also while it was lying dormant probably up until 2019. I think there were some serious concerns even in late 2019 from the European side, but also from the Chinese side. I think in December 2019, we had China's foreign minister say, it's unlikely we're going to reach an agreement because we're a developing country. I think that was code word for we're far apart on the sustainable development aspects of this agreement. A lot changed in 2020, as we know, and this sui generis agreement was completed. I think the test and unique challenge is going to be whether it can get through EU Parliament, particularly without having to request changes from China. We have to remember China is not Canada, it is not Singapore, and it is not Vietnam. I think it will not take kindly to its name being dragged through the mud, involving human rights issues in particularly, while this is pending ratification, and certainly won't take kindly if it is asked to change anything later on. So this may prove to be a challenge. Second, the agreement, I think, won't dramatically change the nature of EU investors and service providers operating in or seeking to operate in China. Of course, for a limited number of niche industries, it's providing true market access. Now, I don't think we can expect an investment agreement, though, to provide a widespread access. FTAs create opportunities. Investment agreements are more codification exercises. They lock in gains. Of course, they do provide some market access, but really they codify existing practice for the most part. So I think the point is that we're not going to transform China into an open regime here. Instead, this is not to say there's no value. The CAI is valuable for locking in some of those investment liberalization measures in China, as Pascal and Maria already mentioned. Many of these concessions, let's be honest, were on the agenda or simply are previously repeated commitments that are being repeated. The removing the joint venture requirement on private hospitals in some major cities, for instance, that's been ongoing pilot since 2014. There's no new access for outside of those cities. That would have been true access. Likewise, opening up foreign ownership to cloud, auto manufacturers in electric and hybrid, right? These are commitments which have been piloted by China at the domestic level, but there is value in locking in those gains, no doubt about it. The point is, we don't expect a major transformation here. So what did the EU get? Obviously, I think the first step is reputational benefits and a demonstration of this strategic autonomy, right? It's that Europe can protect its interest, champion openness, and strike this deal. There is, of course, and I think Maria went through these quite well, of course, the expectation of a better balance in the relationship. That is the market access aspects that I said for niche firms will really benefit from, particularly in manufacturing. There's also the limited liberalization in agriculture, fisheries, mining, energy. These are almost somewhat goods related as well. And then we have those MFN efforts to again codify and grant some new access in services. We need to see the schedules and the reservation lists. Those have not been published yet, so I can't really talk about how deep those in fact are. The second thing, and I think there's actually more value here, but it's being underplayed, is the fairer treatment for the EU investors. This could be in terms of the state-owned enterprise provisions, the transparency for subsidies and services, which of course we don't have at WTO, forced technology transfer, licensing and standard setting. I think these aren't the headlines, but there's real value in there. Some of these put the EU back on a level footing with the US because the US received some of this in its phase 1 deal, but others are new. Third point, sustainable development provisions. Development provisions, I think, won't change the landscape in China. Don't expect that, but nor should we expect them to do so, right? We have provisions here on value-based investing, labor, CSR, environment, climate change, ILO. A lot of these, again, we have to say, is China restating existing obligations. So the ILO, the climate change. China has already actually stated that they would ratify these. I think it's highly unlikely the CAI is going to force China to move. That being said, again, this is a services and investment agreement. We cannot expect it to be a comprehensive labor or environment agreement. If that's what we wanted, negotiate a labor or environment agreement, okay? Don't expect trade and investment to solve every problem in the world. Now, I think that this will also create some internal pressure on European companies who are operating in Europe, who of course have this legal text in their minds. I don't think this is going to encourage or discourage European companies from doing business in China. I think it will be played out, certainly though, in the media and during the ratification process. Now, I think also, I have to say personally, I think the EU is wrong to overplay this aspect of the agreement to prove that it's being a good international citizen here. When it's there, I think the EU is opening themselves up to criticism because it's clear that this is not actually going to force China to really do anything within a certain time frame. I think also critics are wrong to expect something drastic though, right? The reality is these provisions are better than nothing. And with no agreement, European businesses, we're not discouraged from operating in China. We're not discouraged from doing business in China. So in fact, we have something better than we had before. That is not to be criticized. I think that is actually to be celebrated in some regard. Fourth point, China also benefits from the CAI in subtle ways. Now, China receives really little direct and tangible market access benefits that I can see because, of course, the European market is much more open to begin with. This is not to say the European market is completely open, and of course there are going to be some market access gains for China, and in fact the EU also maintained and preserved some sensitive areas, energy, agriculture, fisheries, audiovisuals, etc. So what are the gains for China? I think first is the strategic value of the agreement. It enhances China and China's ability or determination to be seen as an active liberalizer and partner. It enhances China to be their determination to be seen as making an important contribution to liberalization and development. China now also views itself as a leader in global governance. This enhances that. Likewise, so does today's announcement that the New Zealand-China agreement has been upgraded, or yesterday's announcement on that. All three of those things play in. Also, it proves that China can reach a deal with the EU amidst an increasingly hostile environment, particularly with the US. That being said, there's also value for China in this age of nationalism and protectionism and country X first. China gets an obligation that Europe's not going to roll back existing levels of market access and standards of treatment. The fifth point, and I'll only hit on this very briefly because I only have a few minutes left. What's next? Well, what's next is likely to try to complete the agreement on investment protection and some form of dispute settlement. It seems to be a very big stumbling block. The form of dispute settlement, I think ISDS is a no-go in Europe, but it's appearing in all of China's recent agreements, and they seem to like the system. The longer term effect, as I said, I don't think this is going to structurally change China, state capitalism, environment or labor, but what trade agreement can. But these negotiations can lead to and form the basis of strengthened multilateral rules or regional rules on such matters as industrial subsidies, for instance. That leads to the sixth and final point, cooperation or confrontation with the US. Did the EU reach an agreement despite US concerns? Does this give up leverage to deal with China as a united front, as we're seeing a lot of American commentators say? Well, I mean, I will ask, was Europe just simply expected to fall in line and follow with the US in its dealings with China? Of course, the US and the Biden administration wants Europe to cooperate and form this united front, But really, on what grounds can the US object to Europe doing this agreement? In fact, I would say, how dare they? When not only did they start a unilateral trade war, they then reached a unilateral trade deal. And the fact that they would object to Europe reaching a deal, which in some regards, particularly on forced technology transfer and other aspects, simply puts Europe back on a level playing field with the US, I really see no grounds whatsoever for the US to object. And if in fact reaching the unilateral deal weakens leverage, I would expect to see the Biden administration rescind that deal and not want China to meet its purchase requirements on agriculture. But of course, that's not what we're going to see, right? The US is taking the gains, but really doesn't wants to cry foul when the EU seeks to get some gains for themselves. Now, I think this certainly was a example to display the strategic autonomy for the EU and also to drive a wedge between the EU and the US for China. It doesn't need to be the case. I think the EU and the US share, of course, common ground on a number of issues when dealing with China. I won't go into them because of time, but what I will say is, if played correctly, the US and EU can use this deal to begin the process of actually rebalancing the larger relationship with China. They can use this as leverage and bargaining power to deal with China in the future on issues like subsidies and state-owned enterprises. The question I think we need to ask is will the EU continue advocating for change, or will this agreement mean that they will sit on the sidelines now and not force for greater change? So the very short conclusion, because of time, is I think it's a good agreement overall. It's a limited agreement. And I think if the EU promises too much, it's going to open itself up for criticism. To me, it locks in commitments. It's a stepping stone for greater cooperation with the US and others in dealing with China. And to be honest, that's good enough. Thank you.
Thank you, Brian. Well, I'm going to give a right of reply immediately to our keynote speaker, to Maria Martin Pratt, because there are so many issues covered in both of those panel presentations that I thought it might be useful for you to cover off immediately anything that you particularly want to respond to before I open up for Q&A.
Thank you. Thank you very much, Jane, and thank you to both panelists. I must say that I don't have fundamental disagreements with what they have said, and I think their interventions were fair and well informed. Let me just put certain emphasis on a number of points. I fully agree that the CAI is a specific agreement. It's clearly not an FTA, but as I said in my intervention, we never aimed at concluding an FTA. That was not in the cards, and politically, the European Union has been clear in that respect. And indeed, CAI, as concluded in principle, does not include the very specific element of investment protection and investor-to-state dispute resolution. You will find, and you may have seen it, in the final provisions of the agreement, a reference to the fact that the parties agreed to continue the negotiations related to investment protection and investor-to-state dispute resolution. And importantly, clearly it says that the parties will work towards state-of-the-art provisions in the field of investment protection and state-of-the-art provisions in investment dispute settlement, taking into account progress in UNCITRAL. I think that is important. The main difference we have with China, as we have had that, and in some cases continue to have with other partners, is the approach towards investor-to-state dispute resolution. We are not politically or legally in a position to continue supporting ISDS, and we want a system that has far greater transparency and independent, which is ICS or hopefully in the future the Multilateral Investment Court. So we will continue to engage with China because indeed we do want to replace the 26 bilateral investment treaties that member states over the last 2 decades had concluded with China. But that is work going forward. Of the benefits of, and sorry, as regards that, and this is a question that you had also raised, what does that mean in terms of competence? It is very clear that what triggers mixity, and that we know since the opinion of the Court of Justice related to the Singapore Free Trade Agreement, what triggers mixity in our agreements relates mostly to portfolio investment, which is not covered by CAI, and to investor-to-state dispute resolution, that is not covered by CAI. There are some limited aspects related to some very, very specific services sectors, but are not covered by CAI either. So in that respect, yes, we had here an agreement that contains matters that fall within union competence. On the benefits of the agreement, first of all, I would like to say that even if it is correct that there is not a profound transformation in terms of the openness of China, what I think it is also fair highlighting is that some of the openings are important in terms of them not being there before. And that applies to health. Remember as well, we're not referring to the possibility to provide such private health services just on free trade zones, but in the whole of those major cities, that when you're talking about the 5 biggest cities and then the rest of those that have been committed, you're talking about a big amount of population. And the same applies as regards the added value telecommunication services. At the moment, investments were only possible via Hong Kong, not used by our company, but in one specific case. That I think is an important sector as well to highlight as much as others. But also, and in that I do agree with prior speaker, there are elements that have value in the agreement if we use the agreement. And those relates to the disciplines on SOEs with a broad definition of SOEs that you will see in the text, covering SOEs at all levels, as you will also see in the text. And this is important as well, a mechanism that allows us to gain transparency and information when it is not possible for us to determine whether a company is to be considered an SOE or whether, for instance, there are subsidies granted by China to that particular company. These are mechanisms that we have put in the agreement together with state-to-state dispute resolution, because we will use them. It is important to note how much emphasis the European Union is putting in enforcement of its free trade agreements. We are not anymore thinking that, our main purpose is to negotiate. Our main purpose is to enforce what we have negotiated. And there is value in having the possibility to have a bilateral dispute settlement mechanism with China. And I do believe that the European Union will use it if it needs to do so. Final comment, will the European Union continue to want to make efforts in terms of upgrading the rule book in the WTO, working together with the US and other partners to, for instance, get to more ambitious disciplines in the area of subsidies or establish new disciplines in the area of SOEs? Yes, we will. Our objective in terms of WTO reform, working with others in the WTO, working with China to have rules that are adapted to the realities of the 21st century are there. And indeed, CAI should not be seen as precluding our work others, in the same manner that I'm sure the conclusion by Australia or Japan or South Korea of RCEP should never be read as them precluding cooperation with the US and Europe on matters that we believe are of common interest, and confronting China when needed because of practices we believe are not acceptable. Thank you.
Thank you. Maria, there are a lot of questions coming in for all three speakers, and we don't have a lot of time, and I'm going to cluster them necessarily. But the first one is, Brian noted the curious absence of investment facilitation from this agreement, and there's a question there from Pierre Sauvé from the World Bank, similarly asking why, given China's leadership of that initiative in the WTO and the EU support and the opportunity for something bilateral on trade facilitation to signal where one might go in Geneva for the next ministerial on investment facilitation. Why was that opportunity not taken to do something? But I'd actually like to turn that question around a bit, because the question I wanted to ask you is almost the opposite question, and it's really about your own instinctive response to this question. I think you know that most services trade stakeholders have been long supporters, not just of a trade facilitation deal, but a real deal on investment in the WTO. And is what I really want to ask you is, given the systemic importance, as you say, of having MFN-based market access commitments in this agreement, do you perhaps sense that the time to put a comprehensive deal on investment back into the multilateral arena might be coming? It's almost the opposite question from the question others are putting, but I'd like you to answer both if you could, and I'm sure the panelists will have an angle on this too.
Yeah, I'm very happy to reply to that. I'll start by yours, and then we'll go to investment facilitation. I think there's always, at least I find always the need a little bit of a clarification in terms of terminology when we talk about investment and the WTO. The WTO already covers investment when we're talking about services. Mode 3 is investment for services. So in that respect, I think investment is already part of some of the disciplines in WTO and the market access commitments in GATS. It is correct to say that we do not cover the non-services sectors, and manufacturing there is an important element. I'm not saying that there are not aspects in TRIMs or in TRIPS that wouldn't be important for those non-services, but it is, I don't know, probably reality as to where we are there. To what extent do we need to start now engaging into a comprehensive approach to investment, including as regards market access in WTO? I'm not sure that should be our priority at the moment. From my point of view, in terms of priorities in the WTO, as regards investment, indeed, the process of investment facilitation, the discussions on investment facilitation are very important. And so is the fact that you have participation of a high number of members coming from all sides of the membership, from developed to developing and different regions. So I think that is very important. These are negotiations that have really started hardly a year and a half, 2 years ago. There are elements of investment facilitation in CAI when you look into transparency and domestic regulation. The field of domestic regulation and investment facilitation overlaps. I do not think we necessarily had to include all of the issues that are under discussion in investment facilitation in the WTO, and I don't think CAI prejudices that process either. I hope that it's a process that can advance substantially and relatively quickly if we achieve the consensus that we need. Obviously, the devil will be in the details as the negotiations get more concrete. There is an area, but this is not related necessarily with CAI of negotiations in the WTO, that I find that it is even more important, that is digital trade and the e-commerce negotiations, but that probably belongs to a different discussion.
Would either of the panelists like to comment on this issue before I move on with other questions? No. So we have a cluster of questions that relate basically to the sustainability issues in the agreement, but not entirely. But they have something in common, these questions. So I'm going to put them to you in a cluster. We have a question from the South China Morning Post that focuses on the forced labor or the ILO convention side of the agreement, essentially asking how much enforceability might the EU actually have? How might the EU be able to take action if China fails to progress towards ILO ratification? That's one question. We have another question, which has come from the University of Sussex, which is more on the climate change side of things. You know, has climate been ratcheted now to the status of an essential element, whereby if there was a violation, the EU could suspend part of the agreement or not? And then the third question that is related also comes from The Guardian in Australia, noting the recent irritations in the Australia-China trade relationship, and asking, but what about not just non-compliance with the sustainability issues in the agreement, where the agreement might in any case be soft, but what about some of the harder law aspects of this agreement? What happens if there is non-compliance, for example, on the part of China? And this question from The Guardian is pointing out that there have been some accusations recently that China has not been complying with the text of the FTA with Australia. So to what extent have these issues given the EU pause for thought? To what extent, how have you handled them, and how are you comfortable with the outcome? So a cluster of issues there for you.
Okay, thank you. I'll take them in the order that you put them to me. First, as regards the obligations related to sustainable development, and more specifically those that relate to the implementation of ILO conventions that have been ratified, and ratification of the core ILO conventions that have not been ratified. And there, as you will have seen in the text, there is a specific reference to conventions 29 and 105 from the ILO, which are those that are to fight against forced labor. We have commitments in CAI that follow the same level of ambition that we have in other agreements, even if those other agreements are free trade agreements. And in that respect, I think you can, for instance, see that the commitments are practically identical to those that were taken by Korea in its free trade agreement, and where, as you know, there's been recently, it was published the day before yesterday, a report on a specific dispute that we have as regards ratification. What we believe CAI does is impose a clear obligation on China to make continued and sustained efforts to ratify those ILO conventions. And that really means that China will have to take concrete steps toward the ratification of those conventions. And that is an obligation that can be measured over time. So it implies that you must take steps, and it will be increasingly difficult as time passes to justify that you are not getting towards a ratification process. I think by reading what the panel in the Korean recent case expects and acknowledges Korea has done so far, you can also extract how this will function as regards China. I know some people say, well, but there is a reference to its own initiative in the commitment as regards ILO conventions taken by China. But frankly, I do not think that the reference to ratification and its own initiative changes anything. Ratification of international convention in the end is a sovereign decision. It is a decision that needs to be taken by a state upon its own initiative. So that is as regards the value of the commitments that relate to ILO conventions. The sustainable development commitments, so those on labor, those that exist on climate, do have a weight in the CAI also, because if there's no compliance, we do have a mechanism to address disputes, which is equivalent to the one that, for instance, was applied in the case of Korea now. That doesn't mean that these elements become an essential element in the treaty. Essential elements are conditions that we normally include as part of our political agreements, which is different in this case. I think that's important to keep in mind. And finally, what happens if China decides not to comply with obligations in CAI? We have a dispute resolution mechanism. We have a state-to-state dispute settlement. And if after starting a complaint, not being able to resolve, having a panel and a panel finding that, for instance, China was to be in breach of market access commitments, for instance, in the area of health, in the case of not resolution of the situation, the European Union can take action, and that action includes closing market access that has been committed under the treaty, even if that market access has been already committed in the WTO. We have the possibility to take retaliatory measures and close market access for China, even in areas where we already have a self-standing commitment in another treaty.
Now, I know that we have to wind up very soon because Maria Martin Pratt has to leave us for another meeting, although our two panelists can stay on a minute or two more. But I just, I want to note two things. There are quite a few questions which basically ask, why is there no competition policy chapter? And I note our keynote speaker said that competition policy issues were going to be handled in forthcoming unilateral measures domestically in the EU. There are other questions about, well, why is there a deal only on transparency of subsidies and not something more on subsidies? And again, I just note that, wow, there are no disciplines on subsidies for services in Geneva in the GATT. So actually, this is no small outcome. But Maria, before you leave, would you like to comment on either of those 2 points? And one final thing, there is a question from Politico to which I would probably just say you're very well placed there in Brussels to follow up with the Commission spokesperson. However, there are other attendees asking the same question, and so I'm going to put it, and if Maria, you want to say anything, it relates to while the legal scrubbing is going on, there is a story out there that China itself is wanting new language added, and in particular with respect to Huawei. So if you'd like to comment on any of those before we wind up and I let you go. Or has she already gone? No?
No, I'm not gone. I've been having problems with my camera, but no, I'm not gone. Very, very quickly. And let me start by that last point, because I'm a bit surprised. Sometimes we hear in the last few days in relation to the KAI discussion, some arguments that you think, where does that come from? Because they really don't respond to reality. Legal scrubbing is legal scrubbing. The negotiations are closed. They were closed in principle at the end of the year. And I think all of you know perfectly well what legal scrubbing is. It should not be a renegotiation. Lawyers can spend days and weeks sometimes trying to get the right terms, but it does not imply reopening of the commitments. So I do not see how or why people argue that there will be a reopening to conclude or to include, in the negotiated outcome, anything related to telecommunication services or to Huawei, or commitments that will affect our possibility to continue to take the measures we deem necessary to protect our security and public order, including in the deployment of 5G. You can look at the treaty in the same manner that all of our free trade agreements have general exceptions, have security exception, has a space that we need to deploy what we have been doing so far. So stories ongoing as to a renegotiation in parallel by the Commission are simply unfounded. In terms of a stronger commitments as regards subsidies, so commitments going beyond transparency, in terms of subsidies that will be prohibited, subsidies that will be allowed, and with all the possible mechanism that in determining such type of categories. These, in our view, are negotiations that belong to the WTO, more specifically the update of the rules in the ASEM. Eventually as well, it will be important to expand those to services as well. But we have spent a fair amount of time and work already under the prior US administration in a trilateral effort with the US and Japan to try to put some principles in place as to an update of rules as regards subsidies that we would like to re-engage with, reach out to other members and put on the table for discussion in the context of the WTO. We believe that this is a discussion that, to get to the level of ambition that we think it needs to have, has to happen in the WTO.
Thank you very much. I'm going to give just under a minute each to first Pascal and then Brian before I wind this up. Pascal?
Jane, well, I think what I want to say is that there is huge value into locking in and binding existing commitments. And when you know that for the services companies, if you do not have more than 50%, or most of the time you don't have control, companies do not invest. I think that maybe it's not going to be a game changer, but the fact that these commitments are now bound into an international agreement will allow more investment from the services sectors. And I think that is very important. We talk about there is no protection. Well, we have the 25 BITs covering 26 countries out of 27. But our companies don't use it. Our companies will not go up front and attack the Chinese government. It's too risky. You risk retaliation and being expelled out of this market. So we are giving much values to the state-to-state dispute settlement in this agreement. in particular if we hear the Commission saying that they're going to use it. So I think that is more than welcome, and this agreement is very interesting. And for the aspect of the climate and labor issues and saying that the tool has not sufficient teeth, I would say that diplomacy and this dispute mechanism, which is into the TSD chapter, is a very important tool. And I think it's much better to engage with China than to confront China. We have seen what has happened in the United States and the Trump policy, and that has not led to anything but actually infuriating and making things worse. So having a tool which is going to discuss with China, with a normal partner, and engaging with issues is actually a tool that we hope is going to bear fruit. I'll stop here.
Thank you. Thank you. And Brian, a last word from you.
Sure. Look, I have a lot of sympathy for Maria, and I think she's done an excellent job, not only in the negotiations, but on this panel, because of course we can include everything in agreements. And I think at the end of the day, if you've been a negotiator, you know that at some point you have to pocket the gains and move on. I mean, you mentioned digital trade, or dealing with subsidies in services. I mean, there's a reason that subsidies aren't really that comprehensively dealt with in any FTA. And I think this is no different. Likewise, competition, we can always say, well, why wasn't there another one in? But at the end of the day, we have a pretty good agreement, I think. And we go back to my own point. By the way, actually, before that, Pascal, I think we can have another panel just on why European companies don't use ISDS against China. That's a topic in and of itself to explore. But I think I just go back to the main points I made during the presentation. This locks in gains. It locks in Chinese liberalization efforts. There's real value in that. It can lead to, and hopefully does lead to, greater cooperation with not only the US, but other trading partners in further negotiations or further discussions with China. And lastly, it does put pressure on China in regards to the sustainable development issues of CSR, labor, and environment. All wins, that is good enough. Thank you.
Thank you. Well, I think really I do have to wind up now, and I just would like to point out that just this week we've seen UNCTAD report a 42% drop in global investment in the year 2020. Just today, the WTO released its estimates for the last quarter of 2020 for trade and services, still a 29% drop. We're just not yet seeing the recovery in services, which is more deeply impacted than goods trade, and the figures on investment are just completely shocking. So it is quite clear, I think, that actually, wow, an MFN outcome on market access for commercial presence in services is utterly something to congratulate the EU chief negotiator on achieving, because we need such outcomes. The global economy needs them, and the confidence that this helps build back for business is a very valuable thing. So I really just want to thank you very much for joining us for the event. I know you're all busy. It's early for you in Brussels. It's dinner time in Australia. But I think everyone has thoroughly enjoyed the panel. Extremely informative. Thank you very much.
Thank you, Jane.